Good morning. My name is John Rogers. I'm Environmental Manager with the Utah Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, May 20th, 2026. This is time and place for the hearing examiner proceeding for docket number 2026-018, cause number 132-86. In the matter of the request for agency action of U.S.M Operating LLC for an order pulling all interest, including the compulsory pulling of all interests of non-consenting and unknown owners within a 1,280 acre or substantially equivalent overlapping drilling unit established for the production of oil and gas and associated hydrocarbons from the lower Green River and Wasatch formations. Comprised of sections 23 and 24, Township 4 South, Range 4 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We also will be hearing testimony and presentations in person. I guess we're not today, are we?
In person, yeah.
Yeah, but no one's here.
Yeah.
Okay, so we'll have all our witnesses and counsel here in person. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings?
Nobody online.
Okay, let the record show no respondents are present. Okay, we'll now take appearance of counsel this time. Petitioner.
Brent Chicken, Steptoe and Johnson, PLLC, on behalf of applicant petitioner U.S.M Operating LLC.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
And I'm Gary White, Assistant Attorney General on behalf of the hearing examiner, John Rogers.
Okay, thank you. I have received declarations for this matter from Mr. Alexander Yang, a land manager for U.S.M Operating LLC, and will be testifying to issues of petroleum land management. Mr. Yang has not previously testified before this board. Mr. Yang, will you please state your education and work experience to support your qualifications for your request to be accepted as an expert witness?
Yes, sir. My name is Alexander Yan. I have been with U.S.M for over 6 years. Previously, I graduated from Brigham Young University with a degree in geology, so Bachelor of Science in Geology. While I was in school, I interned with U.S.M in a role as a geology intern, and then later on was switched to a land intern. After I graduated, I worked for U.S.M as a lease analyst. My role in my job in that role involved with research, title work, some curatives, and keeping track of lease records. Later on, I moved to do land negotiation. My main role at the time was involved with purchasing leases, purchasing curative documents, and preparing the front end and back end for acquisition, divestiture, and also provide necessary reports for when making business decisions. In 2024, I became one of the land managers at U.S.M, and my current role is kind of a supervisory and management role over the land records in all the U.S.M operated wells, including the well in our compulsory pulling today. It's the Lee 1H well and the Lee DSU. And with this, I also handle various Uinta Basin title and title curative matters. I handle the offers to participate and leasing offers related to all operation support related processes. I also negotiate joint operating agreements and drafting and updating of the revenue deck and the joint interest billing decks and other processes related to operation on behalf of U.S.M.
Okay, thank you. Division, do you have any questions for Mr. Yang?
Yeah, I have a couple of questions, Mr. Yang. Do you have any additional educational certification related to petroleum land management?
I do not. I'm a member of the AAPL currently, and I'm seeking a certification at this time, but I do not have it yet.
Okay. So you indicated you're a land manager. Do you manage other land professionals underneath you?
I do.
Okay. And how many people would you manage?
Right now, so in the past, I've managed from 3 to 4 people. Right now, I only manage 1.
Okay. You indicated that you've been involved in negotiations of JOAs, so forth. Could you just give me kind of just a ballpark figure? How many JOAs have you been involved in?
Good question. So right now we have around 14 currently operated well, and on average there's around 7 to 8 joint operating owners in each of these wells, and I handle majority of the initiating the negotiation for JOA, and drafting and getting approval and finalizing.
And is your experience primarily in the Uinta Basin?
Yes, sir.
Okay. All right. No further questions.
Okay. Mr. Yang, you have kind of a unique background. Geology or the landman. Can you explain how that evolved? Geologists are very bright people, but it's a whole different world over there.
Yes, sir. So my initial education actually started in Australia. I started university in Australia aiming to study geology to go into the mining industry because of the economy over there. When I moved to the States, I transitioned into petroleum geology because my goal is to contribute in the energy sector, because I'm feeling very passionate about providing energy for people and citizens of this country. And in geology, my education revolved around understanding just the natural processes of the earth and how energies are generated, how rocks are deposited. And when I started working with U.S.M as a geology intern at the time, I also discovered that I'm a people person, and I really enjoyed talking to people and negotiating on terms, different deals. So as I was watching the land processes, I became involved, and I started helping out landmen, on setting up appointments and everything. And then later on, I made the transition to working land simply because I can use geology as one of my leverage to explain to landowners why there are opportunity in Uinta Basin and why leasing would be feasible for them both financially and for any other purposes really. So for me, I think the transition was a very successful one. I enjoy both workloads. I still am a very much a nerd, lack of better word, in geology, and I like to discuss that with landowners who also have an interest in that.
Hey, thank you. Very good answer. Appreciate that. I will accept Mr. Yang as the expert witness in this matter. Oh, do you have any objections to that comment?
Well, not anymore.
Okay, let's rewind that. I thought you already accepted it.
No, based on Mr. Yang's comments and his experience in this specific area and this matter, the division's okay with accepting an expert witness for this matter.
Okay, thank you. Okay, as I said before, we'll accept Mr. Yang as the expert witness in this matter. Also, Mr. Trevor Fields, reservoir engineer for U.S.M Operating, has presented a declaration in this matter. He'll be testifying in petroleum reservoir engineering. Mr. Fields has not previously testified before this board. Mr. Fields, would you, again, like Mr. Yang did, state your education and work experience to support your qualifications for your request to be an expert witness in this matter?
Yes, sir. My name is Trevor Fields. I have a petroleum engineering degree from the University of Texas at Austin, and an MBA from the University of Houston. Over my 17 years or so, or 19 years, I've held various roles across oil and gas industry and had a company in real estate development. I've worked as a reservoir engineer, worked on completions, drilling, production, and also did oil and gas lending for BBVA Compass, and worked at a private equity fund. And then now I am at U.S.M Energy, and I've been here a little over a year in a reservoir engineering role.
You went to great schools. We went, you know.
Well, you could argue about what for Mr. Yang went.
I went to the same, to
Oh, yeah.
UT and also to U of H.
Oh, yeah. Hook 'em Horns got kids.
Okay, you done, Regina?
Yes.
Division?
Well, I went to University of Oklahoma, so I don't know. Division.
Okay. Maybe I missed when you were going through that, but what areas have you worked in? What basins?
So for the majority of my career, I've worked basically all the horizontal plays. The Uinta Basin actually wasn't a horizontal play whenever I left. It was just kind of starting to get interest. So in the Uinta, I've only worked the Uinta Basin over the past year, but I've worked Barnett Shale, Eagle Ford, because we are investing in across all the basins. Worked in Pennsylvania. We did a lot of gas horizontal investment. And also I was over purchasing minerals across basically all the horizontal plays in the U.S.
What skills do you bring from those basins that are unique, and how does that affect what you're doing in the Uinta Basin?
Yeah, I would say it's very similar. These are oily with a gas component, but for here the gas component is not the revenue driver, and it's tough to get out of the basin. But I would say as far as the drilling and completion side of it and the valuation side, it's very, very similar. So from those skills, it's evaluating the completion, evaluating the risk in drilling. Obviously, the geology portion of this basin is slightly different, so we're using different fluids, very similar completion techniques, large completions, and then on the valuation side, for us, the valuation is very similar to what it would be in all the other, whether you're in Eagle Ford or, gas plays different, just different stream that you're valuing.
Thank you. Division?
There are no objections to accepting him as an expert in this matter.
Okay, thank you. Well, then we'll accept Mr. Fields as the expert in this matter in petroleum engineering. I have reviewed both the declarations before this hearing, accept them in this proceeding. Does the division have any objections to those declarations?
No objections.
Okay. Mr. Chicken, the witnesses are present here today, so can we now swear them in?
Yes, please.
Would you please stand and raise your right hand? Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
For the record, the witnesses affirm yes to the previous statement. Okay, we'll now proceed in the presentation of the matter with Mr. Chicken. Oh, sorry.
Yes.
Let me stand there. Mr. Chicken?
Thank you, Mr. Rogers. I am going to share my screen here. Entire screen. Share. Okay. Sorry, I'm looking for why is it not there? Sorry. Okay. WEM's request in this matter was filed on March 2nd, 2026, requesting the pooling of all interests in the aforementioned 1,280-acre laydown overlapping spacing unit comprised of sections 23 and 24, Township 4 South, Range 4 West, U.S.M, Duchesne County, Utah, which will be referred to by myself and our witnesses as the subject DSU or the subject lands. That DSU was established pursuant to the board's findings of fact, conclusions of law and order, and docket number 2024-063, cause number 13038, dated January 7th, 2025. That's order 13038, for the production of oil, gas, and associated hydrocarbons from the Lower Green River and Wasatch formations, which will be referred to by myself and our witnesses as the subject formations. With respect to the Lee 4-4-24-33-1H well, which we will refer to as the Lee well. WEM hereby requests that the hearing examiner please take administrative notice of the provisions of Order 130-38 with respect to the subject DSU and its establishment. Pursuant to the State Board of Utah, to the board's order dated 3/3/26, Mr. Rogers was designated the hearing examiner, as previously mentioned. WEM's, pursuant to their certificate of service dated 3/5/2026, true and complete copies of the RAA in this matter were mailed to all interested parties, with the same being mailed to parties whom WEM today seeks to deem non-consenting, sent via certified U.S. mail. Notice of the filing of the RAA and of today's hearing in this matter were also sent to all interested parties by the board and published by the board in the Uinta Basin Standard and Salt Lake Tribune. Notice of the filing of the RAA and the provision of WEM's offer to participate in the subject well to certain non-consenting owners was also published 2 times by WEM in the Uinta Basin Standard, pursuant to the board's March 3rd, 2026 order authorizing the same. This publication is confirmed by WEM's certificate of publication dated April 3rd, 2026. In order to permit a second publication of notice of the filing of the RAA and a provision of WEM's offer to participate to a single additional non-consenting owner, whom Mr. Yang will discuss in more detail. This owner's name was Angela Williams, aka Angela Graham. The board issued an order on April 9th, 2026, continuing this matter from the originally scheduled April 15th hearing to today's hearing. And the board entered an order on 4/9/2026, April 9th, 2026, authorizing that second publication and notice of the filing of the RAA and the provision of WEM's offer to participate. Was then published 2 additional times in the Uinta Basin Standard, and this is confirmed by WEM's second certificate of publication dated May 8th, 2026. The only party filing a response or protest to the RAA was the State of Utah Division of Oil, Gas, and Mining, which noted that subject to WM's presentation of appropriate supporting exhibits and testimony at today's hearing, the division did not oppose the relief sought from the RAA. WM filed its hearing exhibits in this matter on March 16th, 2026. Those exhibits were then supplemented, amended, and or replaced on April 3rd, April 6th, and May 8th. Accordingly, for purposes of today's hearing, WM will be presenting amended Exhibit 1, which is up on the board right now. Exhibits 2 through 9, replacement Exhibit 10, Exhibit 11, 12, 13, and 14. As Mr. Yang is going to describe in more detail, the continuance of the hearing in this matter and the supplementation, amendment, or replacement of the hearing exhibits were driven by the need to provide notice of the filing of the RAA and the provision of WM's offer to participate to Angela Graham, and 2, WM's regularly ongoing efforts to locate and lease successors, heirs, and devisees of certain decedents' estates that are originally classified in the RAA as deceased or unlocatable owners. Specifically, for purposes of today's hearing, WEM is hereby amending its RAA to change the classification of Angela Williams, aka Angela Graham, from an unleased owner as she was represented in the RAA to a deceased or unlocatable owner due to an ongoing inability to locate her. We have several decedents' estates that were listed in the RAA as deceased unlocatable owners. These are the estates of Margaret Ray, Kirk B. Nielsen, Scott Nielsen, William H. Shand, Beth Brown, Sandra L. Howard, aka Sandra L. Davis, Edward Gaborski, and Joyce Werrett Bowers. All of those parties, as Mr. Yang will describe, we're going to remove them from compulsory pooling because WM has been able to obtain final probate orders for all such decedents' estates and has been able to enter into valid oil and gas leases with each one of those heirs or devisees. And the third is to remove the estate of G.W. Nielsen, deceased, who was also classified as a deceased unlocatable owner in the original RAA, from compulsory pooling as to the subject DSU and well. WM has obtained a final probate order for that decedent's estate and has entered into valid oil and gas leases with all but two of those successors. And as to those two remaining successors of the estate of G.W. Nielsen, WEM is in contact with these two individuals, James Adamson and Colleen Martindale. And because we believe we're going to be able to validly lease those individuals, WEM is also just kind of taking the step of saying we're not going to pool their interests. We recognize that if those leasing negotiations were a fail, we would have to come back to the hearing examiner and ask for an amendment to pool those two outstanding interests. But our WEM is very confident that that's not going to be necessary and those parties will be leased. So overall, all of that's a long way of saying that WEM is committed to finding people, finding decedents, finding their heirs, and engaging in good faith, diligent good faith efforts to get those folks leased so that in any case where there is a pooling, we are trying to, compulsorily pool the smallest interest and the smallest number of parties. As folks know, that's not always possible, but that's the goal across the board every time. And so with that introduction, I would like to call my first witness, Mr. Alexander Yang. Mr. Yang, can you please state your full name, your relationship with WEM operating, and your business address for the record, please?
Yes, sir. My name is Alexander Yan. I'm a land manager for WEM. WEM's business address is 4844 North, 300 West, Suite 100, Provo, Utah, 84604.
Okay, thank you very much. As set forth in your declaration, WM is a Utah limited liability company, principal place of business in Provo, Utah, and it is fully and appropriately bonded with all relevant state, local, federal, and tribal entities, including the Utah Division of Oil, Gas, and Mining, correct?
Yes.
I'm going to skip forward here so we're not just reading through the declaration. The exhibits that you'll be presenting today and are familiar with are Petitioner's Amended Exhibit 1, Exhibits 2 through 8, and Exhibits 11 through 14. Is that correct?
That's correct.
Were those exhibits prepared by you or by other personnel under your supervision, direction, and control?
Yes.
And your amended Exhibit 9 is your declaration, and that is also filed, correct?
Yes.
Rather than the declaration contains a brief description of each one of those exhibits that we just discussed. And so I am going to move directly into how are the ownership of interests in the subject DSU and the well determined for purposes of this compulsory pooling application?
The ownership of interest in this subject DSU were determined from the title opinion that we obtained dated June 13th, 2024. It was prepared by a title examination attorney duly licensed to practice law in the state of Utah. This title opinion is certified through March 8th, 2024 as the portion of the DSU described as Section 23 in Township 4 South, Range 4 West, and certified through March 12th, 2024 as to the portion of the DSU defined as Section 24, Township 4 South, Range 4 West.
Okay, and is that title opinion a regularly maintained business record of WEM?
Yes.
And in your role with WEM, you are familiar with that title opinion and WEM's records regarding the subject DSU and well?
Yes.
WEM operating is the operator of the subject well, correct?
Correct.
But the majority of the working interest in the subject DSU and well are owned by WEM Uinta LLC, WEM Uinta 2 LLC, and WEM Uinta 3 LLC, which are affiliates of WEM operating, correct?
Correct.
Can you please identify the non-consenting, or can you please identify the parties that are identified in your declaration as non-consenting based upon the title opinion?
Yes, sir. So these owners are Western Coalition Mines Ltd, Wilbur E. Merrill, deceased, Clara P.C. Merrill, deceased, J. Leo Shepard, deceased, Tom Nielsen, deceased, Richard L. Larson, deceased, J. L. Lindsay, deceased, Clarence E. Bowden, deceased, George C. Cole, deceased, Donald M. Bench, deceased, James A. Morrow, deceased, Howard Aerosmith, deceased, Eva May Casper Tice, deceased, Ferris Casper, deceased, Exelda N. Crabb, deceased, Edith J. Hales, deceased, Charles Owen Weiser and Mariel G. Weiser, both deceased, H. Ray Knox, deceased, Joseph D. Blacko, deceased, William L. Milkey, deceased, Dorothy S. Nielsen, deceased, Therma Green, deceased, Marjorie Gaston, deceased, Edith J. Larson, deceased, Henry A. Johnson, deceased, E. Stanley Klein, deceased, Joseph E. Casey, deceased.
Mr. Yang,
Yes.
just for brevity here, we see all these as an exhibit, and if you're all right
Okay.
with it,
Yeah,
chicken.
I'm fine with that. I'm just trying to be as complete as you need to be. So
Yeah.
if you're okay with that, then that's fine.
So just so you understand, the hearing examiner proceeding is meant to be a little bit more truncated. So the hearing examiner has reviewed all of the documents, he's reviewed the declarations. So you really don't need to recite everything.
Okay.
You can hit high points.
Okay. So recognizing that,
Can I just jump in real quick?
Yeah.
Could you just repeat the ones that were removed?
yeah.
There was about 5 parties. Was it?
Yes, and we can just skip right to that. There are 3 categories of folks that were removed. So what I'll do here is I will go to Exhibit 12. And we will first talk about Angela Williams Graham. Sorry, this JOA is long. Mr. Yang, if you could please discuss, as noted in paragraph 25 of your declaration, the efforts made to contact and the current status of non-consenting owner Angela Williams, aka Angela Graham.
Yes, sir. So with respect to Angela Williams, Angela Graham, WAM originally identified her as a unleased owner in the filing of the original RAA. WAM believed that we had contact with her previously. However, subsequent to the filing of the original declaration, WAM, we learned through our ongoing attempt of delivering the offer, WAM's offer of this subject well to her via certified U.S. mail, we were not able to reach her. We additionally also mailed the RAA to her, believed that it would be delivered, but it was not. As a result, we had to request the continuance of this hearing and the board hearing so that we could pursue a order for a additional authorization by publication so that we could notify Angela Graham via publication with Uinta Basin Standard for 2 consecutive weeks. So as current time, she is still unable to be located by U.S.M. And as of now, we are properly recognizing her as a unlocatable, non-consenting owner for the purpose of this matter.
Can I ask a question right there about, I'll just call it the Graham matter.
Yes, sir.
In the original request for agency action, where do I find that? She was referred to as a unleased mineral owner. Now explain to me why that's any different than just a unlocatable or non-consenting if you can't find her.
Yes, sir. So the distinction that was set forth in the original RA as well as the declaration is if we are able to contact a mineral owner who has unleased mineral interest in our DSU, who has either not made a decision within the 30-day period or elected to non-consent with the offer that we give them, they will be classified as a unleased owner. So such person, in simple words, basically, we know that this person has a valid address. We have established contact with this person, and this person, either by a confirmation of delivery of our certified U.S. mail or through contact or return mail saying that they elect to non-consent.
So what you're saying, she may have signed something, but
she
got the letter but just chose not to communicate with you.
So to basically on this matter is U.S.M originally had contact with her via a different thing. This is actually all the way back when we were seeking for a spacing order in this region. We sent out the request for agency action for all the landowners in the region, and that mail reached her, and she actually contacted us with questions. So we believed we had a correct address. However, subsequently, when we were sending out offers for this well, the package was never delivered. It was returned undeliverable with no forwarding address. So our conception was kind of mixed. We were thinking that she exists and her address was correct because we had delivered something, but this offer turned out was never delivered as we found out.
So she's the only one that is called a unleased owner. But your only reason for putting her in that category is that sometime in the past you had some communication with her.
Correct. We believed that she belonged in this category.
So the remainder of all these people you are reading through, they don't fall in that category. You've never had any communication with them.
Correct. Either that or they're deceased owners.
Yeah, okay. All right, I'm curious as I read through this why she was different, so now I understand.
And
Go ahead.
And so what's up on the screen right now is part of Exhibit 12. And so this was the undeliverable that came back for Angela Williams Graham, correct?
Correct.
And so what happened is that this came back late, correct? It took a long time to come back, I believe, from the post office, notwithstanding the mailing date. And so by the time that came back, that caused the change to move her from an unleased to a deceased or unlocatable for purposes of your declaration, correct?
Correct.
So she's kind of unique in this case.
Yeah.
Okay, thank you. She has clarified a lot.
The second category of folks that used to be listed on the RAA as deceased or unlocatable, but are now being moved off of that list, are set forth in paragraph 26. And if you can just please describe the probate documents, subsequently acquired and the leasing that took place with those parties?
Yes, sir. So WEM always had this consistent effort of locating mineral owners. So subsequent to the filing of my original declaration, as we continued our process of locating owners, we were able to identify Utah State court orders concerning the probate proceedings, as well as the recorded conveyance documents recorded in Duchesne County, Utah, related to the parties that we are now withdrawing from this compulsory pooling.
Okay, and those are the parties listed in paragraph 26, those 6-7 folks. And you have now leased all of their confirmed heirs and devisees, correct?
Correct. Should I expand on that a little bit?
I don't think you need to unless there are questions from the hearing examiner or the division on that.
So essentially what has happened, they've moved from unlocatable to lease through your probate research.
Yes, sir.
And a concern I have is you had 61 originally. Do you do that same analysis for every one of those? I mean, how I'm concerned that also this, what was the name again originally? Cheryl Nelson popped up. And are there others that may pop up down the road too?
That's a really good question, sir. As we know that the world is not stationary, as we reach out to landowners, as other third-party oil and gas companies or lease buyers reach out to people, as the landowners or heirs and devisees of deceased owners get educated about mineral rights, about mineral ownership, they tend to seek legal advice, and they tend to go through the legal process of getting probate done so that the mineral interests that their ancestor owned can be properly legally passed down to under their own name. Because of this transient nature, people are getting their probate done, getting their ancestors' probate done, as we speak. So WEM's continual effort is to keep track of the deceased owners, and if there's a probate popping up, we would get in touch with the identified heirs and devisees on the recorded document and get in touch with them regarding mineral rights ownership. So as for this RAA, as you can see, work had been done during this process. So between when we started and today, we were able to identify the probate records and conveyance documents for the listed owners. And this is part of our diligent effort of finding out, are there still unleased mineral owners out there who are the heirs, and what do we do to go out there and get them? Most of the time, we go through the process and get in contact with them, all that. So in simple words, I believe that our effort is meaningful, and as we continue to go through the process of compulsory pooling and just our everyday leasing effort, we're going to find more heirs receiving minerals through probate. But for this purpose right now, this is everything that we have located.
Okay. The concern I have is, obviously you found this from Nelson down to Adamson and Martindale. As more of these pop up, are you planning on coming back before a hearing such as this or before the board every time one of those happens? And that seems a little bit overwhelming for the division. Or
I think it's more of we have to pick a point in time in terms of the hearing examiner and draw a line in the sand at that point. But if we can, between filing an RAA and the hearing, we can take people out of the compulsory pooling box and put them in the lease box. That's WEM's goal. And so, for example, I know that a lot of the folks that are listed as deceased are unlocatable. There are protective leases that WEM has taken for those people. They just don't have, for the estate of Bob Smith, they have a good idea for maybe an heirship affidavit or something who Bob Smith's heirs might be. but you can't be sure that those are Bob Smith's heirs unless his estate has been probated. And so a lot of those folks, there are already protective leases in place, waiting for probates to happen. And unfortunately, operators can't run around probating things for people.
Yeah.
So, and so that's really, all this is showing is those efforts between filing this in March and the hearing today have taken probably, I don't know, 10 people off of the compulsory pooled list and all of their associated interests, and they're confirmed as leased. But absent that final probate order, you can't be sure that, you may know who his heirs are, but it turns out there's a will in a drawer somewhere and he left everything to the United Way. And so we don't want to find ourselves in a position where we haven't been able to do that. So you have to compulsory pool the folks that you just, or the estates that you have not been able to identify by the date of the hearing. But of course, the other issue too is that any operator can, regardless of a pooling order or whatever, an operator can always say, I pooled your dad's estate, but if you and your brother sign leases, I'm going to treat you as leased and pay you under your lease, and that's also WEM's policy.
And I can see your argument about between the original RAA and hearing, you do the best you can. But what concerns me a little bit here is your footnote on page 10 of the declaration. It's footnote 4. In the event WEM's leasing efforts with Addison and Martindale ultimately prove unsuccessful, WEM understands that it must request an amendment of any order issued by the board to the request for 18 action in order to validly compulsory pool the interests of Addison and Martindale in the subject DSU. So I guess I'm saying, every one of these, are you going to bring it before the board?
That is not the plan. This was very unique. We just haven't been able to get leases from those two people just yet. And WM views that as that's a risk they're taking.
Okay.
In other words, we understand that those two people will not be compulsory pooled today, and we expect them to be leased. If they're not, then we would have to come back and compulsorily pool them. But I don't think this is going to be a regular type of thing. And in fact, I'll note that there was the other matter that was on the docket for today, 13287. We actually withdrew that. To be able, because so much has been able to be identified and changed between the RAA and today's hearing, we just decided it was better to withdraw it and without prejudice, and the board granted that order, and refile that with updated information in the RAA that, again, removes compulsorily pooled parties and removes compulsorily pooled interests. So, I can see your concern is that we're going to be in here every other week, every other month with a bunch of, pull these two people, pull those two people. But I think this is a pretty unique circumstance. Technically, we could say, yes, we're going to pool those two people, but WEM does believe strongly that they're going to be leased. So I don't believe this is going to be a recurring issue for the hearing examiner or for the board.
And as I was preparing for the one we're not doing today, I'll just comment on that. It had 161.
Correct.
And it concerned me, saying, okay, and obviously from the time to now, you found some of those. And so we would prefer that work be done before, like you're doing now.
Correct.
Before it comes to the pulling matter.
Correct.
That, because we think there's some things you can find out there.
And that is exactly why we withdrew instead of filing a 72-page declaration that tried to explain all of that. We have a lot of those names on that 161 person list that when that RAA gets filed again is going to be much smaller.
Yeah.
The lease will be.
And that's what we desire.
Correct.
Okay. All right. Thank you.
Moving on to beyond Graham and the other parties that are leased, we did have one other estate, Gerald William Nielsen, also known as G.W. Nielsen, set forth in paragraph 27, Mr. Yang's declaration. Mr. Yang, if you can please describe how Mr. Nielsen's interests, this decedent's estate's interests, have been treated for purposes of this RAA.
Yes, sir. So as we already discussed, the process that we'll go through locating the probate proceedings and community documents. G.W. Nelson, aka Gerald William Nelson, was one of those person that we have identified the proper documents. With those documents, we're able to identify all the heirs and devisees of G.W. Nelson, and we found out that the vast majority of those heirs has already executed oil and gas leases prior to the filing of the RAA, as to most of those protection leases that we mentioned and Mr. Chicken mentioned before. So with that knowledge, WEM choose to no longer compulsorily pull the interest of G.W. Nelson because the probate has been completed. And we discovered that, as mentioned before, the two heirs, James Adamson and Colleen Martindale, has additional, they own interest in the subject DSU, but portion of that is unleased or their lease previously expired. So they're, as to that portion of the mineral interest, the current status is unleased. So like Mr. Chicken has expounded on, WEM elected to not compulsorily pull those interests and choose to take the risk at this time.
And I've put up Exhibit 14, and this is the delivery confirmation to both James Addison and Colleen Martindale regarding WEM's offer to participate, correct?
Yes.
And they did not timely respond within the 30 days, correct?
That's correct.
So both of these parties would technically be non-consenting parties for purposes of this pooling, but again, WEM is willing to take what it believes is a small risk here and not compulsorily pool them, and instead finish their leasing negotiations with those parties, correct?
Correct.
Was there any further questions about that from the board or hearing examiner or the division?
We'll let the division actually done.
Okay, sure. I'll just move on. As set forth in paragraph 30 of your declaration, the various WM entities mentioned before, what is their percentage of working interest ownership in the subject DSU and well?
WEM entities owns 93.593958% of the working interest in the subject DSU and well. The non-consenting owners, together with the unleased owners identified as Adamson and Martindale, they own a total of 99.402497% of the interest in this subject DSU and well.
And so that percentage is the total amount of interests that are not being compulsory pooled, correct? So 99.402497 is the working interest that is consenting.
That's correct.
And so what is the percentage of working interest in its subject DSU and well that WM is seeking to compulsory pool today?
It is 0.597503% of the interest in the DSU and well.
Before we move on from that, can I ask a few questions?
Sure.
This is interesting because the original amount, we get cut up in the numbers here, for WEM's operating interest on the request for agency action is, I'm going to just abbreviate this, 93.468%. Okay, now we move up and it goes to 93.593%. So it increased. You're obviously going to be a higher amount because you have more people.
Correct, because of the parties that have been leased.
Okay, now.
Correct. And that does include the Adamson and Martindale interests.
Okay. So now let's look at this. The original, well, now we go down to all working interest owners, WEM and the other ones. The original number was 99.403. The new number is 99.402. I know a minor amount, but it seems like those numbers don't correlate. One's going up, one's going down.
And that is because we addressed that in on page 11, footnote 5. We include one of the changes did cause a change in that number and the other did not cause a change in that number. And that's why they're confident with WEM owning 93%, 93.59%. When you add in the other consenting owners and the unleased interests of Adamson and Martindale, you own, it goes to 99.402. And so that's why those numbers have changed and why we're confident in the 0.597503% is what would be compulsorily pooled here.
So that again is greater than the original amount. What would be compulsory pool?
And Mr. I'll go ahead and let Mr. Yang further explain that.
Yes. So thank you for noticing that. Allow me to lay out the timeline a little bit. This matter was the first time that WEM is going through this process. We are building a process as we go, as we learn. Like Mr. Chicken explained, that this is very much, we learn how to do this, so the next one will be better. When we filed the original RAA, the numbers identified as the WEM entity-owned total working interest and the total working interest of all consenting owners was actually erroneous. There was some calculation that we did that we excluded certain interests that WEM had already leased and taken as protective leases from the heirs and devisees of the deceased owners. And then we put that into the category of the other consenting owners. So let me explain the logic here a little bit. We outlined our process in page 11, and maybe we're unique, maybe WEM is unique in this situation, but we would take protective leases with heirs and devisees of deceased owners, and we're talking about we run our own title, we do our own research, and we believe we're very good at that, and we're really good at understanding unit basin title, which is very complicated, and we'll go through details, lots of work to identify the potential heirs, putative heirs. So when we identify those heirs, when we lease with them and have a protection lease, we have two options. One option is we only treat that as a protective lease and it doesn't necessarily contribute to WEM's working interest or NRI. Or we can take the risk involved with and credit those putative heirs as actual mineral owners, pending the necessary legal requirements on their title. So the path that we chose is the second one. So in the matter of force pooling, in this Lee DSU and the 1H well, WEM is actually only seeking to force pool the unleased portion of the working interest of the heirs and devisees of deceased owners in this area. So if, in simple words, in other words, if a deceased owner has heirs that already leased with WEM, we would like to treat that as a valid lease. We want to credit that working interest, NRI and royalty interest, and we want to take that on as a working interest. So this process maybe is unique, has benefited us and benefited landowners. Of course, we communicate with them, we educate them on what legal process they need to go through to completely, settle the title of their mineral rights. But we believe, without going through force pulling those interests, they're going to get a higher royalty rate, landowner royalty rate, and eventually it's better for everyone. So that's the process. And then I reiterate what I stated at first. The original RAA, as we filed, the WEM owned working interest and the total consenting owner's working interest was erroneous, and we corrected it in my previous declaration and now being amended. And now the correct WEM-owned working interest is stated in this declaration, paragraph 30. And the consenting owner total interest has gone up and the forced pulled non-consenting owner's interest has gone down, that is due to the change of James Adamson and Colleen Martindale.
So as I notice this, I'm seeing these contradictions here. What you're saying is that the request for agency action, those numbers were essentially incorrect.
That's correct.
Okay. So if I compare them, it kind of threw me off there. Okay. You use a term there that I'd like to clarify. And this is from paragraph 1 of from the original request for agency action. They're talking about the term leasehold working interest owners who have either affirmatively refused to or bear their proportionate amount on the well. So as I think as a working interest owner, that's someone that chooses to participate in the well. How can they be a working interest if they're not going to participate?
So I'll answer that question. By definition, if a well, let's put it this way: if a person owns mineral rights and they're not subject to a lease agreement or a contract of leasing out their mineral rights, they are default as a working interest owner. For the purpose of our notification and mailing and sending out U.S.M's offer, we treat them as a working interest owner, and we send them a form with the election that has their opportunity to participate with their unleased working interest, or they could choose to lease their working interest to U.S.M as the operator, or they could sell or non-consent. If a working interest has already been under a contract being leased by a third party, then U.S.M would treat that third party as a working interest owner with a leasehold working interest. And when we send out a election to that party, we would only have, before I mentioned 4 options, right? So participate, lease to us, sell potentially if they wanted to, and non-consent. But to a leasehold working interest owner who has the working interest and have burdens on their working interest, then the election we send to this party would only be to elect to participate with their working interest and potentially sell the leasehold to us or non-consent. The difference really is the unleased working interest owners have the opportunity to lease out the unleased interest versus not having it.
Maybe I can ask.
Well, they're not really a working interest owner. They're a possible working interest owner.
So this is my question. I think the issue is W.M. defines a working interest owner as the party with the right to drill for and appropriate and sell oil and gas. That interest can be either unleased or leased. And so if you are a leasehold working interest owner, you're the party with that right subject to a lease. And if you're an unleased mineral owner, that means you still have the right to do that, because you could always participate in your minerals, correct? Like you could elect to bear your share of costs and get your share of production and not have any lease on your mineral interest. So I think that's really the key here, is that's how WEM views what a working interest owner is. And that's the right to drill and to develop. And so that interest could be leased, it can be sold, or it can be participated.
Well, everyone that does this has a little bit different definitions. This was new to me.
So that's just how we view it. And I promise you, I don't think if you looked up working, it just is smiling. There's no definition in Utah law that says working interest means this. And so, but the commonly understood at least from WM's perspective, and I would say from mine as well, is if you have the right to drill, you have the right to enter the property and drill and produce and sell that mineral, you have a working interest. It's just a question of, is that a leased interest? Is it subject to a contract for development, or is it unleased? Most famous unleased working interest owner ever being Union Pacific Railroad. right? Like they would, through their various iterations, they would participate minerals and, they would very rarely lease that stuff. So, but that's our view from the purposes of the RAA, and that's why there are really 4 categories. There's leasehold working interest owners that consented, leasehold working interest owners that did not consent, and then unleased mineral owners that either leased or agreed to participate or didn't respond and are therefore not consenting.
Okay. Continue on.
Excuse me, John, I got an email from a member of the public that is saying they are trying to get into the YouTube channel and they
So-
want to comment. Is that?
So historically, we do not offer commenting on the YouTube channel.
Okay.
She would have to join the Google Meet, or he or she would have to join the Google Meet in order to participate in public comment.
Okay,
We can offer that as an option if she wants to comment.
Can you tell us who that person might be? So that he can.
Well, you can send her, that's how she can,
I will go out and
she
call
can
her.
listen to it, but then appropriate time, we may allow her to say something.
So you do want me to send her the Google Meet?
I mean, this is, the first time we've come across a public commenter that hasn't either, like previously either said, I want to comment or shut up.
So send her the link for everything, and we will address that at the proper time.
I'm just going to continue
Sure.
while they're doing that. I would like you, Mr. Yang, to also describe the processes and investigative efforts that WEM applies in terms of identifying decedents' estates and their respective potential heirs, successors, and or devisees, in terms of not only confirming that it is an actual decedent's estate, but then also how you try to identify their heirs, devisees, and successors.
Absolutely. So, 2 parts of this process. So at first, we conduct the investigation regarding the deceased non-consenting owners that we identify from the title opinion. What we do is we first try to locate certificates of death, and in the cases that we cannot locate those short documents, we then would search online records for indicators of death, including obituaries, social media, and commercial information sites. The sites we use, one of them is LexisNexis. And after all those efforts, then we review the age of the conveyance documents that vested title in the deceased owner, allowing WEM to make a reasonable knowledgeable assumption regarding whether this owner is deceased or not. As an example, if we locate the vesting the document and is dated 1940, you have to be age of 18 to sign the deed like this, then we assume that this person's over 100 years old and this person is probably deceased. And after we have, after this process, we then conduct the investigation to find the probate documents and the conveyance documents through, number one, we search the online Utah State Court records. The website is called Exchange Public Case Search. And after which, we search the online database maintained by the recorder of Duchesne County, Utah, for the recorded conveyance documents. And this is a process that we go through. And other than the before noted probate documents, we have not able to identify and locate either the current probate documents or the conveyance documents for the deceased non-consenting owners that we seek to pursue.
And just to, I'm trying to find the appropriate level of detail here. Exhibits 5 and 6 are WM's examples of their offer to participate as to all of the non-consenting owners identified in paragraph 24 of your declaration.
That's correct.
Okay. And can you please briefly explain what each one of those offers contained and explained to the parties it was sent to?
As in like the entire offer package?
I just mean, that, well, let me do this. Did each one of those offers explain that the non-consenting owner was owner of interest in the subject DSU and well?
Yes.
And that the WM was proposing the drilling and completion and operation of the subject well in the subject DSU?
Yes.
That each owner was entitled to elect to lease, participate, or have their interest compulsorily pooled?
Yes.
And did that also include an authorization for expenditure detailing the cost to drill and complete the subject well?
Yes.
Okay. Did that offer also include a copy of the JOA set forth on Exhibit 6?
Yes.
Okay. And can you just please very briefly describe the terms of that JOA and why WEM believes that it is a reasonable JOA?
Yes, sir. So the Exhibit 6 outlined the true and complete copy of the JOA that we sent out as part of the WEM offers to all owners. And this JOA is a slightly modified version of an AAPL 610-1980 model form operating agreement. This form agreement is regularly used, this form agreement is regularly used by WEM and other Uinta Basin operators, and it contains terms and provisions that WEM believes to be reasonable and customary in the Uinta Basin. The operating agreements contain terms and provisions similar to those set forth in the JOA, have been voluntarily agreed to by Uinta Basin operators and non-operators, including unleased mineral owners and including all consenting owners with respect to the subject DSU well.
Okay, and the risk compensation award in that JOA is 100% for surface equipment and 300% applicable to drilling and completion costs?
That's correct.
And with respect to Exhibit C to that JOA, which is the COPUS, if you could please describe what COPUS is for and the interest rate provided in there.
Okay. So Exhibit C to the JOA, it's a form governing the accounting procedures to be employed by WEM as operator under the JOA with respect to the cost of the subject well, the use of which is reasonable and customary in the Uinta Basin. The COPUS section 1.3 is entitled Advances and Payments by Parties, which provides for the assessment of interest on late payments concerning the cost for the subject well. Such interest rate is based on the applicable prime rate as published in the Wall Street Journal plus 3% per annum. If the Wall Street Journal ceases to publish such prime rate, then such interest rate is instead based on the prime rate published by the Federal Reserve plus 2% per annum. The COPUS Section 3 addresses the applicable overhead charges that one may impose with respect to the subject well and the JOA parties' rights and obligations in connection with the subject well.
And so is it your opinion that the terms and conditions of the JOA, including the provisions of its Exhibit C COPUS, are reasonable, customary, and regularly used in the Uinta Basin?
Yes.
And WEM has entered into operating agreements such as this multiple times, both as an operator and a non-operator?
That's correct.
I did recite the notice provisions earlier, and there are filings regarding all those notices, but I don't know if there's any question on notice from the hearing examiner or the division.
Not from me. We'll turn the time over to the division for questions.
Okay. Has WEM received any communications or been in contact with any of the non-consenting owners listed in paragraph 24?
I'm not.
We'll move on to your last exhibit here, which will be Exhibit 7 for purposes of the hearing today. If you could please describe what Exhibit 7 depicts and how it was calculated.
Yes. So Exhibit 7 depicts the calculation of acreage-weighted average fee landowners' royalty interest in the subject DSU and well, and the acreage-weighted average fee landowners' royalty interest is, as calculated, shown on the last page of this exhibit, is 18.394455%. I just want to note that this interest has also changed from the original filing of the RAA, and the reason was we missed 2 leases that we should have included within this table of calculation, and in my original declaration we were able to correct that, and on this amended declaration it is now the correct interest representing all representing the acreage weighted average fee landowners royalty interest.
I don't have any further questions unless there's other questions from division or hearing examiner.
Okay.
Oh, thank you.
Division?
Yeah, sure. Let's just stick right here. You indicated that you missed 2 leases. Were those leases taken prior to drilling?
Correct.
Yeah. Just want to clarify.
Yeah.
So, so just so we're clear, the average weighted royalty is the amount in the exhibit and in your declaration.
In the amended declaration, yes,
Okay.
sir.
And also the pooled interest is the amount in the declaration of the RAA.
That's correct.
Okay. Thank you. You've clarified a lot of the questions I had. I don't really have a ton more. I do have one question though about in the unlocatable parties. There's a company, Royston Coalition Mines Limited. Could you just tell me a little bit about why they are an unlocatable?
Yes, sir. The genesis title of Royston Coalition Mines traced back from 1940s. It's back then we believe that this company was one of those mining companies that was set up, back then in Utah, and they had a principal office, the place of business, addressed in Boston Building in Salt Lake City. They no longer there, and we could not find any business record of this entity on business registration and all the other online searches that we have employed. Not in Utah, not in any other states that we diligently searched for. And since the conveyance document was from the 40s and we have no information giving us any more additional addresses, we're just not able to locate this entity at all.
Okay. Just one last question. You indicated that, if I remember right, these wells spud in October, November. Your title opinion was good through sometime in March of that year. Was there any thoughts to supplementing that title opinion up to the time of drilling to help? Would that have captured any of the deceased parties that currently probated? Would there have been any benefit to taking that step?
That's a good question. I can definitely see the benefit of doing so. As an operator, we'll also have to weigh that against the cost of purchasing a title opinion. As we all know, title opinions can be costly, especially in the Uinta Basin.
Sure.
Yeah.
Thank you. Yeah, no further questions from the division.
Thank you, Mr. Yang. We'll now move on to Mr. Fields. And before we start, I have received your declaration. And is that your testimony?
Yes, sir.
And I assume you'll be adding to that through Mr. Chickman's questions possibly today?
Yes, sir.
Very limited. His testimony is pretty straightforward and really hasn't changed. Mr. Fields, if you could please state your full name, association with WM, and business address for the record, please.
Trevor Fields with WIM Energy at down in Provo, Utah.
Okay, thank you. And your declaration notes that you are familiar with amended Exhibit 1, Exhibit 5, and Exhibit 8. Is that correct?
Yes, sir. And
those exhibits were prepared by you or by WM personnel under your supervision, direction, and control?
Yes, sir.
Can you please briefly describe how WEM drills wells in terms of batch drilling?
Yes, sir. This well was part of a 2-well program off of a single pad. This is cost effective for WIM. It also benefits all parties involved, leaseholders and leasees, mineral owners, by reducing the cost of our drilling by batch drilling off of a single pad.
Okay, and for this particular well, what was the capital expenditure for this well prior to first production?
The actual cost was $8.936 million, and 8.936.
Okay, and was that did this well's actual costs come in below the estimated costs that were contained in WM's offer to participate in AFE?
Yes, initial estimates was 10.18 million, and so we were 1.249 million below initial offer.
And so looking at that, that's Exhibit 8, correct?
Yes, sir.
I can get there. And these exhibits are voluminous for these matters. And that difference is depicted in Exhibit 8, correct?
Yes, sir.
Right below the other one, and I just skipped over it. I just want folks to see Exhibit 8. It is. Sorry. Somehow I missed it in there. I keep missing it. Anyway, Exhibit 8 has been filed. I don't want to belabor this and take longer than folks need to. But Exhibit 8 is prepared by you and is part of your exhibits, correct?
Yes, sir.
What is the proportionate share of costs to drill, complete, and equip the subject well that it would be associated with the non-consenting owners described by Mr. Yang?
It is $53,398.39.
Okay, and so that's the total amount of costs that the list of non-consenting owners will be collectively responsible for?
Yes, sir.
Okay. And so based on your descriptions in your declaration, do you believe, is it your opinion that the financial, technical, logistical, and operational risks inherent in drilling, completing, and equipping the subject well and the subject DSU justifies the requested 100%, 300% risk penalty?
Yes, sir.
I have no further questions for Mr. Fields.
Division? Go ahead.
Yeah, I've heard Gina Echo with the division with me. She's a petroleum engineer. Did you want to?
Yes, so with the cost that you just mentioned earlier, about the 53,000 that would cost the non-consenting owners,
Correct, that's,
where is that in the exhibit?
that is our exhibit. It's Exhibit 8, and I'm looking at this, and I don't know that I put that in there, so give me a second.
It's not an exhibit 8.
So that number is in Mr. Fields' declaration at paragraph 17. So that's not actually in Exhibit 8. Exhibit 8 is just the difference between the estimated and actual costs, but that $53,000 number is the total cost that would be, the total actual costs that would be associated with the 0.5% interest that is being compulsorily pooled. So the consenting owners bore the difference between 53,000 and 8.9 million.
Thank you.
Yeah, the division has no further questions.
Okay, thank you. Few questions.
Mr. Rogers, just so you are aware, we do have Ms. Walker.
Okay, once we finish here.
Yeah.
We'll allow her.
That's fine. I figured, I just wanted to make sure you were aware that she was able to join.
Thank you.
Yeah.
The penalty, the risk, 300%. It's a very popular number. We've, it's just sort of given out there, you know, and as I've worked in the basin here and I've seen these wells go from 15 million, 12 million, 10, what was this, an 8, almost 9?
8.9 actual, 10 something estimated, just 10,000 or 10,186,400 estimated, and total final cost was 8.9 million.
And then I see the plugging costs have also gone down. I mean, what it's estimated, of course. What was it on this one? It was 100,000 or?
I'd have to look, but it's usually around 100,000.
Yeah.
I believe so.
So I'm just questioning this risk amount. Can you give me a little more reason how you got to that number? And since, you know, 10, 15 years ago, the risk was probably much higher for these wells, but now we're seeing the same risk amount.
Yeah, I would say, you know, with the horizontal drilling, there's a lot of inherent risk. We see losses of well bores. We leave debris in the hole. We don't get the full lateral length. And also, even though the costs come down, that comes down through, some of it is through efficiencies when we can, but we can't always get those efficiencies. And then also, that also depends on oil prices. So here, whenever we were drilling this well, you know, the market was suppressed, so we were able to get equipment in a timely fashion. Now that's back up. So there's, you know, that risk kind of is still there, and I would say is higher in a horizontal well because you're putting so much in and you have so much risk of downhole equipment as you're drilling those wells and the loss of well bore. And you have the well bore open and loss of integrity coming up. And we see, and we are partners in wells all the time that have material issues. And oftentimes those wells, when you have issues, you're never going to get your money back because there can be sometimes catastrophic, or you're sidetracking a whole lateral, which does happen.
Okay. Just always address those risks. That's a big concern.
Certainly.
When the boards will sometimes ask about that. And so
That one, yeah. Although their statute lets them go to 400. So we are asking for less than the max. And I do think a lot of this has to do with, that's, you know, most JOAs, you're going to be seeing 100, 300, although I'm sure we've seen wildcat area. I've seen JOAs with 1,000% put in there because it's so far out in the middle of nowhere. The risk is off the charts. But duly noted that, you know, if the risk is coming down, the risk penalty should, you know, match that.
Yeah. I have no more questions. Yeah. Okay.
Can I admit,
We have her online.
can I admit my exhibits?
Oh, yeah, sure.
I would just like to move that it amended Exhibit 1, Exhibits 2 through 8, amended Exhibit 9, replacement Exhibit 10, and Exhibits 11 through 14 be admitted to the record.
Okay.
Mr., do you have any objections?
No objections from the division, then?
Okay. So accept it. Let's go to our online. Where's the name of that?
She's right here. I believe it's Vicki Walker.
Hey, Vicki, can you hear us?
Yeah. If you can hear us, go ahead and unmute your connection and then turn on your camera. Carmen, maybe you can help us with the unmuting.
I can't unmute her. I can only mute her.
Vicky, are you there?
Yeah, did you have a number for her?
Yeah, I've been texting with her, so I just sent her a text.
I mean, you could even call her and put her on speakerphone. I mean, that does work.
Let's see what Penny thinks.
Okay.
Can I interject real quick, just because I was forwarded?
Yes, were you able to unmute and turn on your camera?
Hold on, just hold on.
Yeah, we can't hear you, nor can we see you.
So at the bottom of her screen, there should be an icon with a microphone.
Vicky, I'm gonna put you on speaker.
I'm
Yeah.
sorry, my computer appears as though I am unmuted. And you can tell by the feedback that I'm unmuted.
Well, that's just your speakers. Do you have any?
Matt?
Well,
Have her leave and come back in.
You want me to leave and come back in?
or could we just accept her public comment over the speakerphone? Would we rather have her on the Google Meet?
Okay, let me close my
As long as we
computer
can
so
hear
we
it,
don't have
I'm
that
fine with
feedback.
What's that?
All right,
Let's just
I
do that.
wanted first of all to tell you my qualifications.
Well,
My
wait.
Hold on.
Where are you going?
I
Can you
was
get
gonna
it?
bring that closer to you.
Well, can you get it? Will this pick it up?
Yeah,
It's picking up, just like.
yeah, it'll pick her up.
Can you hear me now?
Maybe just have her. introduce
Yeah,
herself.
will you identify yourself? This is John Rogers, a hearing examiner. Will you identify yourself and then you can make your comments?
John, my name is Victoria Walker. My qualifications are that I was a title officer, escrow officer for 22 years for a large commercial title company in Utah. Subsequent to that, I was a commercial real estate agent for 14 years. So I have a background in real estate. I have made 4 calls to U.S.M, of which I received 2 return calls from Mr. Yang. I've written them 2 correspondence, and they did not approve the paperwork that I'd given them. I am a member of a family that originally, in the original title reports that were provided, there were 5, that left a interest in a long ago distant relative. They said they could not find his probate. Subsequent to that, I found the probate, provided that to U.S.M. There is still an ongoing matter. I've talked to U.S.M about accepting some documentation. They have refused to accept that documentation, even though as a title person I would accept it. They are requiring an order determining the heirship. So it's a court proceeding, which we are in the process of doing. And even over the Memorial Day weekend, my plan was to go to Tabionet and take care of the matter. I do not know if my family is on this list because I haven't received anything in writing from U.S.M. So the documentation that you're referring to, I don't know if we're part of. It could be that this matter doesn't apply to my family, but to my knowledge, they are pulling all of that together for anyone who is deceased. I don't feel like U.S.M has been helpful. And I believe that with my background, I can't be the only person who is having difficulty proving their title. And that it could be, I cannot be the only person who is still in the process of doing that. So I object to pulling the interest at this time.
Ms. Walker,
Yes,
can you tell me who the descendant you're referring to that you inherited this property?
Francis Brooks, and that was the one that we determined, I found the probate. And May Tice was one of the people that received an interest in his will. And that is where my interest would come from.
So what's his relationship to you?
May Tice is a great aunt.
How do you spell Tice?
Tice.
What was the first name?
Her full name was Eva May, M-A-E, Tice. Sometimes she is referred to as May, M-A-E. Sometimes she is referred to as M-A-Y, Tice. She died intestate in 1990. And that's the person that we're working on determining the heirship.
So we see her name there. Let's begin. It's Emma May Casper Tice, deceased.
Yes, yes. And it's Eva, E-V-A.
Oh, Eva. That's spelled last one. Mr. Yang, would you like to respond to that?
Yeah, I'd love to respond to that. Well, first of all, I'd like to acknowledge Ms. Walker. I have spoken to her, and in fact, both of our departments, the owner relations department and me, both spoken to her. And for me personally, I've been on the phone with her for over an hour, explaining the situation, the title, and the history in the family of Casper, of the Casper family, and explain to her the necessary legal processes that she must go through to vest the title in the current living heirs and devisees of, in this case, Eva May Casper Tice. I personally believe that we have done our due diligence of locating as much as we could the heirs and devisees of May Tice, and then extended lease offers to do protection leases with those heirs, and then paid the lease bonuses according to the interest that they would be receiving as putative heirs of the family. Due to the complexity of the family and the title, I can expound on that if needed. We are not able to credit those protection leases as a valid lease, even though we want to. The interest right now that's resting in the estate of May Tice is very small, and whether it goes either way, it would not move a needle in this situation. In fact, at this moment, even though Casper May Tice, this name is on the our forceful agenda. We really have not accounted for basically this interest as one's interest.
Can you draw the relationship between Vicky Walker and Emma Tice?
Eva May Tice.
Eva.
Yeah, I could certainly do that. It's pretty lengthy. It's a very big family.
Well, I don't think we need the whole detail of it, but you do see her in there.
So what I see is that, and with talking to her, I understand that she's a distant niece of Eva May Tice, because Eva May Casper Tice did not have any issues when she passed away and when her husband passed away. So the relationship is distant.
I am.
Can I further just?
Like one at a time here. Let's Mr. Yang finish, and then we'll talk to you, Ms. Watson.
Yeah, I just want to further state that the conversation we're trying to provide with Ms. Walker, and we will continue to provide her with conversations and give her not legal opinion, but general directions from a land professional with good faith on how the necessary steps to take to complete the necessary title work to prove her title. Sorry, I lost my train of thought. Just one sec. And I recall the document, and Ms. Walker can correct me on this. I believe that she tried to provide documents to us that are affidavit in nature, but does not necessarily vest the title in her as a distant heir/relative of the deceased owner. So in short, we will still continue to assist her in this matter. She has my personal number. I have her phone number saved in my phone. And, we have a lot of processes to go through. But when times permit, I always try to give her time to address this, and I will continue to do so.
The probate documents she provided, you saw those, I take it?
I don't believe that she provided any order determining errors to us,
Which she doesn't have a probate.
I don't believe so.
She just said she
For instance, Brooks, we have a probate, and yes, I provided documents to him.
So
There are two additional probates that are being done. One is finished and one is still in the process. So I did not know, as mentioned, I did not receive a copy of the notice. And so I did not know that time was of the essence. So that document has not been provided to him yet, and the other one is still in the process. And yes, he's right, the interest is very small. However, if I'm being pooled, that matters to us.
That's okay.
So
She just said probate is in progress. We need a probate for Eva May Casper Tice. That's the record owner. That's what we need.
That's the order that is in the process.
can you say that a little bit louder so she?
Sorry.
That is the order that is in the
She did hear
process.
Ms. Walker, my name's Brent Chicken. I'm counsel for W.M. operating here. And the record title ownership of this interest ends in the county records in Eva May Casper Tice, who is deceased. And in order to get from her to you, we need final probate orders actually identifying and conveying the property from the personal representative of Eva May Tice.
I am aware that is your position.
Right,
And
right,
that is the position that Mr. Yang has represented.
right. Well, and it's not our position, it's the law.
I was always hopeful that you would take a determination of heirship affidavit, but he made that very clear the last time I spoke to him, that was not the case.
Correct, and
So,
that's because
as
that,
mentioned, we have two
right.
probates ongoing.
And that's great, and I think WM will continue to work with you, but Utah's a uniform probate code state, and to transfer real property from a decedent estate, from a dead person to their heirs, you need to have a probate and an order of a probate court and a personal representative's deed. And there may be, in your case, because you're attenuated as a niece, there may be several probates. And in the title examination world, these are called waterfall probates, and they happen all the time where
I'm aware of that.
yeah, the last owner is great grandpa, and you've got to get it through 4 generations of people. And so, as long as that happens, then I'm sure WEM could work with you on that. And we actually mentioned earlier that, just because an interest is pooled for legal purposes doesn't mean that it can't be treated as leased based upon the proper information. And you're acknowledging that there's probates in progress right now. And so I would encourage you to please keep WEM apprised of the status of those probates, so that as those orders and those PR deeds start getting issued and recorded, that WEM can update its records.
So WEM would be willing to work with her as she starts the probate process.
We always work with anyone that's going through the probate process.
Right. We just can't do it for them, and we,
Yeah.
advise that they get counsel to help them with that.
Do you understand that, Ms. Walker?
I do.
Does that satisfy your needs, knowing that he will look into this, and then you also have issues that you need to take care of?
Yeah, I understand that I have things that I have to take care of, and as said, during the process. I guess what I don't know was I thought as soon as as it was pooled, we basically lost any claim.
Oh.
Yeah, will you respond that?
I will. You don't lose a claim. What happens is that your share, or I should say the record title owner, Eva Mae Casper Tice's share of the costs of drilling, completing, and operating the well are recovered by the parties that are actually writing checks for those costs right now. They're recovered from your share of production, along with what's called a risk compensation award, because
Which
that
is
is
300%.
100, right. But
And do you
once,
consider that fair?
well, but once,
Whereas I'm continuing to work on it, do you figure that's fair?
well, until, right, and you would also, since this is unleased, there is a landowner royalty, the average weighted landowner royalty that is paid to that non-consenting party, while the people that actually wrote the checks are recovering their cost. And once the cost is recovered, that interest becomes a working interest in that well going forward. So you're not going to lose your interest. This is so that the parties that paid Eva Mae Casper Tice's share of costs in this well, which based on the interest here is a couple of $100, if that, they're going to recover those costs, a 100-300 penalty, pay the landowner royalty, the average weighted landowner royalty during the recovery period, and then that interest afterwards becomes a working interest owner in the well going forward.
So you consider, if I understand what you're saying, you consider that charging me the penalty is acceptable by pooling me. Now, legally, you're allowed to do that, but do you consider that fair? And why would I say yes to that?
Well,
let me ask you this, Mr. Chicken. Would you be willing, if she's working through this probate issue and say she gets it where it needs to be, would you be willing to take her from a forced compulsory pool to a leasehold owner? I mean, convert that?
yes.
Yes,
Yeah.
absolutely.
And would you go back to the beginning or just from the date of the probate?
Then we go back to the beginning.
We go back to the beginning. I mean, right now, the problem is you go to the county records in Duchesne County, and that interest is owned by a decedent who doesn't.
And so
have
that's got to
heirs.
be taken care of. So even
Right.
now, there'll be no royalties, nothing will go to anyone.
No, this
Until-
whatever that royalty would be held in a suspense account
Yeah.
until the period of time to submit it to unclaimed property and that's how that would be handled. Because there is no person to pay. If we had a personal representative of the estate of Eva Mae Casper Tice, they could sign an oil and gas lease today.
Yeah.
But we need that PR to be appointed by a Utah state court in order to give them the authority to sign that lease. And then every single heir and devotee would be covered by that lease, and they would all then get their share of royalty under that lease going forward. But that's our problem right now, is we don't have somebody that can sign a lease for Eva Mae Casper Tice.
So would you be willing to put that in the draft order if I approve of this action?
I don't see why not. I'll have to make that description. But yeah, I mean, that's the bottom line, is that's the record title owner. That's who would need to sign the lease. And if we had a PR for that person, then that person could sign a lease.
So Ms. Walker, do you see where we're going on this? This gives you,
I do.
And
I do, and then I would like one more thing. My title reports are from 2023. Can you give me your updated title reports?
We'll do, we'll do.
We'll do what we can.
okay,
I don't know.
did you hear that? They'll do what they can at this point.
I mean, the title, the answer to your question, the updated title report is Eva Mae Casper Tice owns this interest of record and is the legal owner, and her personal representative is the only one that can affect that interest unless her estate gets probated and the PR conveys that interest to her heirs and devisees. So, I mean, that is the title report right now, that has not changed in the county records of Duchesne County.
Okay, so are you telling me you haven't updated the title reports?
Well, there is nothing to update because the decedent here, Eva Mae.
Well, there's a ton to update. The title report that I have says Francis Birch owns this. I went out and found your probate.
Okay, Ms. Walker, I'd like to just ask you, given the situation, would you prefer to be, if given the choice, a working interest owner or just to sell your minerals or Eva's minerals? What's your choice?
I don't know the answer to that. That would be a question I would have to ask somebody who knows more than me.
Well, I think we've covered things here, and I think they'll be in communication with you. We will put that in the order, and but you got some work on your side to do.
Yes, sir.
And contact them and continue to work with them. Okay.
Thank you.
Okay. Thank you.
Thank you. Bye.
Okay. Where were we?
I had submitted my exhibits and I'm done with the examinations.
Okay. And did we get time to the division? Or so did you have any questions for the?
I'm happy to make a statement when you're ready.
Okay. All right. We did receive a letter of non-opposition from the division. So that was received on May 11th, 2026. So you want to make a closing statement then?
Yeah, happy to. As indicated, the division filed a notice of non-opposition to this request. We worked with U.S.M in the process of the original filing and then the continuation. And based on our review of the request and the exhibits and the testimony we heard today, the division continues to have no opposition to this request and feels like the U.S.M has met the statutory and regulatory obligations for compulsory pooling this well, the interest in this unit and well. Just to comment also on the public comment that we heard, the division feels that, again, U.S.M has done what was required of them. If there are parties that have not met their legal obligations in the county records, that falls on the party. And as far as we've been told, U.S.M has listed the parties that are part of the county record, and then so we feel comfortable allowing them to proceed with the request.
Thank you, James. Well, would you like to make any final closing statements?
I think our only statement is thank you for everyone's time today, and we again request the compulsory pooling of all interests in the subject DSU and well as set forth in our RIA and as corrected in our declarations and testimony today.
Okay, thank you. I can take a few minutes to talk with my counsel here out in the hall, so we'll be back in a little bit.
Sounds good. Hey, Carmen, we'll go off the record.
Okay, having reviewed the request for agency action and all exhibits, and having considered the evidence presented today, I find that W.M. Operating has provided sufficient notice of opportunity to the non-consenting compulsory pool owners and those owners identified in the request for agency action, and did not timely elect to participate in the wells, therefore should be deemed non-consenting parties. I find 100% for the surface equipment and 300 for drilling costs as a non-consent penalty is fair and justified given the economic and geological conditions present with this well, and find it to be appropriate to impose the requested non-consent penalty. I find that W.M. Operating has met its burden of proof to show that they are entitled to force, pull, the name interest, and other relief requested in a request for agency action. Mr. Chicken, will you prepare the order?
Yes, I will. And just so I understand how that works, once I've prepared it, who should I send that to for review? Mr. Haynes first or Mr. White, or the two of them?
I'll follow at the same time.
Yeah.
Okay,
Is this copy of?
not a problem. I just
And-
want to make sure that,
Patty, do you want to see that too? Or do you want to wait till it's finalized?
We would prefer to see it after everybody else has
Okay.
reviewed it, because we get kind of lost in the weeds when we get
so we work on it, finalize it, and then I file it.
Yes.
Okay.
Yeah, because we may have comments.
No, and that's the idea. I had an issue with proposed orders.
That brings up another difficult situation because a week from today will be the hearing and I have to report on it there.
I'll get it turned around this week.
Yeah, Friday'd be good because Monday's a holiday and then we have
Yep.
two more other than this. And so
Correct.
that would be helpful.
I will get it to you as soon as I can get it to you guys, so that you can look at it. It will follow general standard order formats and things like that, except for our few people that are pulled out, not getting pulled. And I will make a comment in there about Miss Walker, and you guys can evaluate that as well.
Well, I'll present the findings and conclusions from that in the hearing next Wednesday. Any other comments before we close?
I have none.
Vision?
No.
Gary? Okay. Well, we'll adjourn this meeting at this time. Thank you.
Thank you.
Why don't we take a break? If anyone needs to, we'll start in about 5 minutes or so. All right?
Okay.
Good morning, my name is John Rogers. I'm Environmental Manager of the Division of Oil, Gas, and Mining. Before we get started, I'd like to recognize that on our agenda, number 2 matter, docket number 2026-21, cause number 132-87. This matter has been withdrawn and dismissed without prejudice. Anything you'd like to add, Division?
Nothing to add, no.
Okay, all right. We'll continue on to the matter with SM. I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner of this proceeding. Today is Wednesday, May 20th, 2026, and this is the time and place for the hearing examiner proceeding for docket number 2026-024, cause number 132-88. In the matter of the request for agency action of SM Energy Company for an order pulling all interests, including the compulsory pulling of the interests of certain non-consenting and unknown owners in the 2 Frank wells identified herein, within a 2,560 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch Colton formations, comprised of section 28, 29, 32, and 33, Township 2 South, Range 1 West, Winter Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. Before we begin, are there any members of the public or respondents present that wish to comment on the proceedings?
There are none online.
Okay, anything that's with
None
you?
that I'm aware of, yeah.
Okay, great. Let the record show no public respondents are present. We'll now have a presentation of counsel. Petitioner?
Thank you, Mr. Rogers. Mitch Mayo with Lear & Lear PLLC on behalf of the petitioner SM Energy Company.
Division?
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Assistant Attorney General Gary White for the hearing examiner.
Okay, thank you. I have received declarations for this matter from Mr. Levi Dean, a senior landman for SM Energy, and will be testifying to issues of petroleum land management. Also, Mr. Brad Peterson, the Utah Region Asset Manager for SM Energy. He will be testifying as a petroleum reservoir engineer. I read both of these declarations before this hearing, and at this time, I'd like to note that Mr. Dean and Mr. Peterson have both testified before this board, Oil, Gas, and Mining, as expert witnesses. Does the division have any questions for Mr. Dean or Mr. Peterson at this time?
Nope, we're willing to accept them as experts.
Okay, great. Mr. Dean will be accepted as an expert witness in petroleum land management, and Mr. Peterson will be accepted as an expert in petroleum reservoir engineering. Does the division have any objections to their declarations as presented?
No objection.
Okay, Mr. Mayo, I see the witnesses are present today. Can I have you stand as I swear you in? Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
I do.
Seated. Go ahead.
Yep. And just one note, Mr. Peterson didn't stand, but it wasn't out of a lack of respect. I think he was trying to make sure he was still in the camera frame, so.
Yeah, I was trying to figure out how I was going to do that, to be honest, so.
Sure.
That's right.
Okay. Where were we here? For the record, the witnesses affirmed yes to the previous statement. We'll proceed to Mr. Mayo for his presentation.
Thank you, Mr. Rogers and everyone here. I would like to know before I start, with me today and sitting behind here is a new attorney at our firm. Her name is Rachel Howden. She's been helping me with some of the board work and learning the process, so you may see her around. If you do, be nice to her. Please say hi. Now, that was a great introduction. With me today are the 2 witnesses, Levi Dean, senior landman, recognized as an expert here today in petroleum land management, and Brad Peterson, the short but polite swearing inner over there. He is the Utah Region Asset Manager for SM, and he will be testifying today as an expert in reservoir engineering. As you noted, consistent with past practices, we filed their sworn written testimony before this, I believe it was a week ago on May 13th. Those are filed as petitioners exhibits 11 and 12. And in keeping with those past practices, the witnesses are here to answer any questions you have about those declarations. The board and by designation, the hearing examiner, have jurisdiction over this matter pursuant to Utah Code annotated 40-6-6.5, and the implementing regulations. A copy of the request at issue here today and the notice of opportunity to participate was sent by certified mail to the known parties to be compulsory pooled, and sent by regular mail to all other production interest owners within the what we'll call the Anchorman Old School 2560 at their last known addresses disclosed by the relevant realty records and as supplemented by SM's internal records. In addition, this was sent to all institutional parties, BIA, BLM, TLA, trust lands, etc., as required due to mineral ownership within the unit at issue. These were all mailed as outlined in paragraph 26 of Mr. Dean's declaration and as memorialized in the certificate of service filed on April 15, 2026 in this cause. Additional evidence of the proofs of these mailings and the return receipts were filed as Exhibit 14 on May 12th, 2026. That exhibit will continue to be updated or supplemented as we receive additional proofs of service. In addition, notice of the filing of the request and this hearing was also duly published in the Uinta Basin Standard on April 22nd, 2026 and April 29th, 2026. Exhibit 13 is a true and correct copy of the affidavit of publication. On May 11th, the Division of Oil, Gas, and Mining filed a response expressing no opposition to granting this request pending the presentation today. There were no other objections or responses to the request that have been received. This cause involves the compulsory pooling of a 2560-acre drilling unit established by the board under one order, the 600-04 order entered in June of 2021, which was subsequently amended to reduce the heel toe setbacks by order entered in March of 2024 in cause 130-29. Those will be referred to as the current orders. As Mr. Rogers mentioned in the outset, those orders established this unit for production from the Lower Green River, Wasatch, Colton formations of sections 28, 29, 32, and 33 in Township 2 South, Range 1 West. In accordance with the current orders, SM drilled and has begun to produce from the 2 Frank wells together, and they may be referred to as the subject wells that were identified in the RAA. Those wells being the Frank 50-3328-21B, which spud on March 1st, 2024, and had a date of first production of March 24th, 2025. And the second well is the Frank 70-3229-21A, which spud again on March 1st and had the same first date of production of March 24th of 2025. There are 29 owners of undivided oil and gas interests who were named on page 2 of the request for agency action to be compulsorily pooled. Since filing the request, none of these owners have reached out or otherwise leased or agreed to participate with their interest in the Anchorman Old School unit. Accordingly, that full list of names on page 2 of the request remains to be pooled here today. In addition, as addressed in paragraphs 17 and 18 of Mr. Dean's declaration, several estates are named to be pooled on page 3 of the request for agency action. Although SM believes it has leased all of the successors of those estates without those conclusive court orders determining that, out of an abundance of caution, we must pool those estates here today. Again, similar to the named parties, since filing this request, SM has not received any leases or elections to participate or conclusive probate documents from any of those named estates. So that list on page 3 is the list that we've pooled here today. As reflected on Exhibit 8 and discussed in paragraphs 30 through 32 of Mr. Dean's declaration, the average weighted royalty as of the date of spud of the first Frank well, which happens to be both of the Frank wells with this issue, is 17.384246%. Costs, including estimated plugging costs, we believe are just and reasonable, and the risks incurred justify the 100-300% risk compensation award requested, both as discussed in Mr. Peterson's declaration. in paragraph 15. With that, I'm ready to begin with my witnesses confirming the declaration testimony.
Go ahead.
Mr. Dean, you've been sworn in. Would you please state your name and business address for the record?
Sure. Levi Dean, that's 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay, and what is your position with SM?
I'm a senior lineman.
Okay, does that role provide you with responsibility over this drilling unit?
Yes, it does.
Okay. Have you seen what's been filed as Exhibit 11, the Declaration of Levi Dean?
Yes, I have.
Okay. Do you recognize it?
I do.
Are you familiar with all the allegations contained in that declaration?
Yes, I am.
And did you execute that declaration or cause your counsel to execute it?
I have instructed you to execute it.
Okay. Does that declaration, as conformed to the rest of this hearing today, represent your full and accurate testimony in this cause? Is there anything else you'd like to add?
Not this time.
Okay. One last question before, in your expert opinion, having been recognized again as an expert in petroleum land management, are the terms and conditions of the JOA, which was submitted as Exhibit 7, do you believe they're fair, reasonable, and just to be applied in this cause?
Yes, I do.
Okay. With that, I turn Mr. Dean over to questions from the division and hearing examiner.
James?
Not a lot of questions. In your declaration, you indicate that a packet was sent out to Susan Chappelle, but then it could not be located. So another packet was sent out.
Correct. Yeah, when we did the initial mailing out in 2024, she had a PO box for an address, so we didn't get confirmation of the delivery.
Okay.
Hence, when we were putting this together, that's why you sent her a brand new notice of opportunity to participate.
Okay. That was March 6th. It sounds like, have you heard anything back?
I have not heard nothing.
The other question I had regarded Roosevelt City Corporation. Is that the city of Roosevelt? Who is that?
It is, yes. Yeah, it's the record title owner. It's the city of Roosevelt.
And they gave you no response back?
Correct, yes.
Okay, interesting.
And this is not the first matter they've been fooled in.
Sure,
So
sure.
must be a policy or practice.
Other than that, I don't have any specific questions. We did address return receipts, Exhibit 14. From my review, I only really see like one party. I think we don't have anything from Ward Retailer. That's the only one that I'm waiting on.
Well, maybe I can clarify that. You know, what we're here today is we're talking about the Anchorman Old School section line. A couple months ago, we did the Anchorman 1280 on the other side. And when we did that, Ward Retailer's name was included to be pooled. He had received a valid election at the time. When we mailed out that request and went through that hearing, it wasn't until after that hearing concluded and the order issued, we got notice back that it's a dead address for Mr. Taylor now.
Okay.
So we, made the choice to essentially, he's received full notice of his opportunity to participate, and he was provided notice of the hearing, but not, we had no way to mail him a copy.
All right. Sorry, I'm just looking at one last thing. Yeah, all right, thank you. No further questions. Thank you.
Just one point here for if we do approve this matter. In the order, I always like seeing a summary of, operator's working interest, non-operator's working interest, and then just the compulsory pull. It never fails that one of the board members asks, well, how much is this? I can dig it out of there, but just so we got a final, because sometimes these numbers change. This one doesn't look like it's going to change much.
And I'm thinking you're talking about like the exhibits that Ovinted used to file, where it's just the little table there.
I like that.
I'm happy to put one of those in. That's no problem.
And I have no questions for Mr. Dean.
Okay. With that, I'll quickly move on to Mr. Peterson. Mr. Peterson, same thing. Would you please state your name and confirm your business address for the record?
Yeah, it's Brad Peterson, 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay, and would you please tell us what your title is and what your responsibilities are broadly and kind of specific to this unit?
Yeah, I'm the Utah Asset Manager. I'm responsible for optimization of development for SM's Utah asset.
Okay, and obviously that would include all the drilling units within it, including this one.
That's correct.
Okay. Mr. Peterson, same set of questions that I asked Mr. Dean. You've seen and you're aware of, well, are you aware of what's been filed as Exhibit 12, the declaration of Brad Peterson?
Yes.
Okay. Have you reviewed that document?
Yes.
Are you aware of all the allegations that are contained therein?
Yes.
Okay. Does that declaration, well, did you sign that declaration or ask counsel to sign that declaration on your behalf?
Yes.
Okay. Does that declaration still constitute your full and complete testimony at this hearing? Said differently, is there anything you would like to add or change to that declaration testimony?
Yes, no additions or changes.
Okay, thank you for answering that complicated one is yes, one is no question. Finally, is it your expert opinion, Mr. Peterson, that the costs in this unit were, reasonable, fair, and necessarily incurred?
Yes.
And do you believe that a 300% risk compensation award is justified based on the risk presented?
Yes.
Okay. With that, I don't have any further questions for Mr. Peterson, subject to the division and hearing examiner.
Okay. Mr. Hank?
Yeah, thank you. The division has no questions for Mr. Peterson.
Okay. Mr. Peterson, you've heard this before. I'm always concerned about the risk penalty. And just, can you explain to me exactly what we're talking about? In here, your declaration, it says, where'd it go? It's my opinion that financial, technical, operational risks inherent in batch drilling the subsea wells in anchor hole 250-60, especially when considered in conjunction with additional wells drilled, it should be 300%. Can you kind of give me a list of what exactly, I know we've talked about this before, what causes that to be a 300% risk versus a 200 or even lower?
Yeah. So, I think they're, drilling wells, and especially, drilling a lot of wells in an area, you're kind of setting yourself up for, you don't have much time to look at the data and change your development plans. So there could be differences in spacing optimization. There could be differences or mechanical failures. One of the issues that we have had some struggles with on the 10,000-foot designs is liner hanger failures. So, those have significant excess costs north of, $1 million. We also, as we're drilling the wells, the formation's complicated. We do a lot to try to stay in these very tight windows to drill wells. But, when we get out of those, a couple things that could happen is we will have to sidetrack a well, which is very expensive. Also, in some instances, we have troubles fracking some of the stages due to, high pressure seams that we drill through. So, like you can see there at a very high level, we AFE'd these for an amount, and we were over by about $800,000. So on a per well cost, there was additional costs that we ended up realizing on these wells versus we did some additional issues. We're able to get them drilled and online. But it did cost us a little bit extra money versus our plan. So those are some of the risks and, things that we really come into account for executing the wells.
Okay. Well, thank you for that detail. As was mentioned earlier, the response, division filed a response of notice of non-opposition to request. It's therefore my understanding that the division has no objection to the request for agency action. Accurate?
Yeah, that's correct.
Okay, and do you have any questions for this witness? Oh, we already went through you, didn't we?
Yeah.
Okay. Sorry about that. That was so
No,
quick.
you're good.
Okay, Mr. Hank, would you like to make a closing statement at this time?
Sure, thank you. Yeah, the division, they reviewed this request for agency action. They reviewed the associated exhibits and filings, including the declarations that were also filed as part of this hearing there today. And based on the testimony given and the declarations that were reviewed, the division continues to have no opposition to this request and believes that SM has met their statutory and regulatory obligations.
Okay, thank you. Mr. Mayo, would you like to make a concluding statement?
Just two quick comments. One is to move for admissions of the exhibits 1 through 14 inclusive, and that will include the declarations that were submitted and vetted today.
Do you have any objections to that?
No objection.
Patty, did you get those, or do you need to know what those were? You got them? Okay, great. Thank you.
And my second comment is just to thank everyone for their time and attention and ask you to approve the request as completed.
Okay.
You're good.
We'll admit the exhibits as presented. Sorry about that.
That's-
Okay. All right. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented today, I find that SM Energy has provided sufficient notice of opportunity to non-consenting compulsory pool owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells, and therefore should be deemed non-consenting parties. I find that 100% for surface equipment and 300% for drilling costs as a non-consent penalty is fair and justified given the economic and geological conditions as explained today. I find that the SM Energy has made it burden of proof to show that they are entitled to fourth pool named interest and relief requested in the request for agency action. Mr. Mayo, would you please prepare the proposed order?
I'm happy to do that, and hopefully, I've got a draft put together, so hopefully I can get it to you this afternoon or tomorrow.
Okay, good. We appreciate that with the holiday weekend. And okay. I then will present the findings and conclusions to the board next week at the board hearing. Any other comments before we close? Okay. Thank you for your participation during this proceeding at this time. Okay, let me move on to number 4. Okay, Matt, are we good to go?
We're good to go.
Okay. Good morning. My name is John Rogers, and I'm environmental manager with the Division of Oil, Gas, and Mining. I've been appointed by this board, Oil, Gas, and Mining, as a hearing examiner in this proceeding. Today is Wednesday, May 20th, 2026, and this is a time and place for the hearing examiner proceeding for docket number 2026-025, cause number 132-89. In the matter of the request for agency action of SM Energy Company for the order pulling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners in the 10 Frank and Tank wells identified herein within a 1,280 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch Colton formations, comprised of section 28 and 33, Township 2 South, Range 1 West, Winter Special Meridian, Duchesne County, Utah. We are holding this hearing with an anchor position in the Department of Natural Resources Building in Salt Lake City, Utah. We will also be hearing testimonies and presentations in person and virtually, and proceedings will broadcast on the internet. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings?
There are none online.
Okay. Let the record show there's no public respondents present. We'll now take appearance of counsel at this time.
Thank you, Mr. Rogers. Mitch Mayo of Laird & Laird PLLC on behalf of the petitioner SM Energy Company.
Division. Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Assistant Attorney General Gary White on behalf of the hearing examiner today.
Thank you. I have received declarations for this matter. Mr. Levi Dean, the senior landman for SM Energy, and will be testifying to issues of petroleum land management. Also, Mr. Brad Peterson, the Utah Region Asset Manager for SM Energy. He will be testifying as a petroleum reservoir engineer. I reviewed both of these declarations before this hearing. Mr. Dean and Mr. Peterson have both testified before this board, oil, gas, and mining as expert witnesses. Does the division have any questions for Mr. Dean or Mr. Peterson concerning their qualifications?
No questions.
I need to accept them as expert witnesses at this time.
Division, yes.
Mr. Dean will be accepted as an expert witness in petroleum land management, and Mr. Peterson will be accepted as an expert in petroleum reservoir engineering. Okay, and we swear them in again?
Either way, I'm comfortable reminding them, but
You can just remind that they remain sworn.
Okay. My counsel told me just to remind you that you've been sworn in and consider that process we added the previous matter continues. Okay.
Unless you want Brad to stand up this time.
Let's see how tall he really is. Okay. Hearing examiner, let's see, I gotta go here. Well, now turn the time over to Mitch Mayo.
thank you very much, Mr. Rogers, for that introduction. As you noted, with us today are Levi Dean, senior landman with SM. He's here in person, and pursuant to board authority granted on May 6th, appearing virtually is Mr. Brad Peterson. He's the Utah Region Asset Manager for SM Energy. The witnesses have both been sworn in or reminded that they're under oath, and their testimony today will be considered to be under oath. And both will be recognized or have been recognized as experts in their respective fields. Consistent with past practices, as Mr. Rogers mentioned, SM submitted its witnesses' sworn written testimony last week. Those were filed as Exhibits 12 and 13, respectively, for Mr. Dean and Mr. Peterson. And like I said, those were filed on May 13th. The board, and by designation, Mr. Rogers as the hearing examiner, has jurisdiction over this matter pursuant to Utah Code Annotated 40-6-6.5 and the implementing regulations. A copy of this request and the notice of opportunity to participate was sent by certified mail to the known parties sought to be compulsorily pooled, and sent by regular mail to all other production interest owners within what we'll call the old school unit at their last addresses of record. Those addresses were determined by looking at the Duchesne County Recorder's Office and also by examining SM's internal records. In addition, this was mailed to all the institutional parties that we typically mail to: Trust Lands Administration, Forestry, Fire and State Lands, and the federal and tribal agencies, as required due to mineral ownership within the old school unit. All of these mailings occurred as outlined in paragraph 26 of Mr. Dean's declaration and is memorialized in the certificate of service on file April 15th in this cause. In addition, any evidence of return receipts or proofs of these mailings being delivered has been submitted as Exhibit 15 on May 12th and has been supplemented once on May 15th and will be supplemented again if we receive additional return receipts. On May 11th, the division filed a response expressing no opposition to the granting of the request, of course, pending the presentation of evidence here today. And just like to note, no other objections or responses to the requests were timely filed. To summarize this case, as Mr. Rogers did a little bit, this cause involves compulsory pooling of the 1,280-acre drilling unit established by board order in July of 2016 in cause number 139-138, as subsequently amended by the order entered March 2024 in cause 130-29. I may refer to those collectively as the current orders. All of those orders authorize oil and gas production from the Lower Green River, Wasatch, and Colton formations, and comprising the entirety of sections 28 and 33 in Township 2 South, Range 1 West, U.S.M. In accordance with those current orders, SM drilled and has now begun to produce from the 10 Frank and tank wells identified in the request for agency action. And unfortunately, I probably should read these. I'll go quickly. Frank 54-3328-21G, which spot on March 4th, 2024, with a date of first production of March 26, 2025. The Frank 34-3328-21F well, which spot on March 4th, 2024, first production on March 24th, 2025. The Frank 72-3328-21D well, spot on March 1st, 2024, with first production on March 26, 2025. The Frank 71-3328-21C well, spot on March 1st, 2024, with first production on March 24th, 2025. The Frank 62-3328-21E well, spot on March 4th, 2024, first production on March 26, 2025. The Tank 65-3328-21I well, spot on March 4th, 2024, first production March 25th, 2025. The Tank 58-3328-21K well, spot on March 6, 2024, with first production on March 26, 2025. The Tank 75-3328-21H well, spot on March 4th, 2024, first production on March 26, 2025. The Tank 57-3328-21J well, spot on March 4th, 2024, first production on March 26, 2025. And finally, the Tank 78-3328-21L well, which spotted on March 4th, 2024, first production on March 25th, 2025. There were only 10 owners of an undivided oil and gas interest in the old school unit and the subject wells that were named to be pooled. Those names appear on page 2 of the request for agency action. Since SM has filed the request, none of these parties have leased or otherwise committed their interest to the old school unit, such that that list of 10 names is the list to be pooled here today. In addition, as addressed in paragraphs 17 and 18 of Mr. Dean's declaration, 10 estates are named to be pooled on page 3 of the request for agency action. Although SM believes it has all heirs or devotees under lease and pooled, out of an abundance of caution due to the gap in title, those estates are all here to be pooled today. But again, similar to the non-consenting parties, since SM filed the request, none of the estates have provided conclusive documentation or reached out to lease or participate. Accordingly, the full list of estates on page 3 of the request remains to be pooled today. Finally, as reflected on Exhibit 9 and discussed in paragraphs 30 to 33 of Mr. Dean's declaration, the average weighted fee landowner royalty as of the date of spud of the first Frank or tank well is 17.949689%. With that introduction out of the way, I'd like to turn to my first witness. Mr. Dean, can you please state your name and, well, first remind you, you're under oath at this hearing. Could you please state your name and business address for the record?
Sure. Levi Dean, 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And remind everyone here what your position with SM is and the responsibilities.
I'm a senior landman.
Okay. And do you exercise responsibility over this drilling unit?
Yes, I do.
Thank you. Are you aware of, have you seen what's been filed as Exhibit 12, the Declaration of Levi Dean?
Yes, I am.
You're familiar with all the allegations contained therein?
Yes.
And did you cause counsel to sign that declaration on your behalf?
I did indeed.
Okay. Does the declaration constitute your full and accurate testimony here today?
Yes, it does.
Is there anything you'd like to add or modify in that declaration?
No.
Okay. Last question. In your expert opinion, do you believe the terms and conditions of the JOA, which was submitted as Exhibit 8 in this cause, are fair and reasonable, customary in the basin for horizontal development?
Yes.
Okay. With that, I have no further questions, and we turn them over to the division and hearing examiner.
Mr. Haynes?
Just a quick question. I think it was touched on. You had a title opinion effective to November 11, 2023. We do have these deceased estates that are there. Has there been any supplement a review of record title to see if any of these states have had anything filed or anything happened
Yeah.
between now and this hearing?
We've looked in the county. There haven't been any. If they do come up prior to this hearing, then we would remove them from the filing. But there have not been.
And just to answer your question from our perspective, when we are asked to do a compulsory pooling and given that list, we search exchange for any probates that have been done. Whether they're recorded or not is more of a marketable title question. So as long as we see that, then we've got places to send it out.
Yeah, all right, thank you. Yeah, no additional questions.
Okay, I have no questions for Mr. Dean, thank you.
Okay. Mr. Peterson, remind you you're under oath again in this hearing, and would you please state your name and confirm your business address for the record?
Yeah, it's Brad Peterson, 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And what is your job title at SM?
I'm the Utah Asset Manager, responsible for development planning and optimization for all of SM's acreage, including this unit.
Okay, thank you very much. Have you seen what's been filed as Exhibit 13, the declaration of Brad Peterson in this cause?
Yes.
And have you reviewed, do you recognize, are you familiar with all of the allegations that are contained in that?
Yes.
And did you execute or have your counsel execute that declaration on your behalf?
Yes.
Okay. Do you have anything you'd like to add or modify to that declaration testimony here today?
No changes or additions at this time.
Okay. In your expert opinion, Mr. Peterson, were the well costs reasonable and necessarily incurred?
Yes.
Are the actual costs, in your expert opinion, within a reasonable variance of the AFE costs?
Yes.
And finally, do you think the 300% risk compensation award is justified based on the specific facts in this request?
Yes.
Okay. With that, I have no further questions for Mr. Peterson, subject to questioning.
Okay. Mr. Haynes? I have not been given any questions to ask engineering wise. I don't profess to know anything about it. I do have a question though regarding there's 10 wells. They were all spud and then came on about a year later. Just my understanding of this batch drilling does that save time, batch drilling, rather than going into one at a time? Like, how does that process work? And you don't have to be really detailed. I would just
yeah, I can cover that for sure. I mean, I would say it's actually takes a longer time because when you're drilling like these pads, 10 wells, for example, you know, a lot of times we're doing it with 2 rigs. But if you went out there with 1 well, you'd be with one rig, you move off, it allows completions to come in faster, facilities work to be done faster. And really what drives that is we can't be drilling next to the frac group. So we try to, you know, if we're developing in the same zone, laterally 1 mile, we put a 1 mile buffer in there. If we're going up probably, you know, 600 feet or more, we can get a little bit tighter, but in these cases, all these wells were within, you know, the 600 feet. So you go in, you drill, you have your completion. We work through all the timing, your completion's back a mile. And so while you're drilling all these wells, you know, there's this buffer that causes some of the cycle time. So, yeah, in this case, you know, what we've done, and it also depends bigger picture on the amount of like rows and wells. So like if we're doing a long, like this one was like, I think a 5-section development where we developed 5 sections totally. You're kind of, you got to space a little bit more on the front side of it, or else when you're fracking with your cadence, you'll catch the rig by the end of the row. So shorter rows are better for, you know, reducing cycle time. But in this case, it was on kind of the beginning of a long, we call them long runs, development runs.
Yeah. And were these all on the same pad, or was there two pads here?
I'll have to look, but they're like, yeah, I'd have to look for sure. They're, I think it's two.
Yeah. I think this one was off one pad.
It was off one.
I believe so.
Okay, great.
But we can confirm that for you for sure.
But the thing that's important is a lot of times we'll go to one pad, but we'll send two rigs to one pad. So that's why I have trouble keeping it straight, because even if we send two rigs there, whether it's a broke up pad by 500 feet or a larger pad with two rig locations, that's why I struggle to keep that straight sometimes. But ultimately we are, at that time we were developing probably with 2 to 3 rigs. So we've never sent more than 2 rigs to one pad. So that's kind of how we expand depending on the surface, try to minimize surface disturbance, and work with the landowners in the areas, get the SUAs, and then we line up kind of how we're going to drill them, whether multiple pads or one big pad. But it's better, due to the waxy crude, it's better to put more wells closer together, because we have to heat all the oil to 140 degrees, or else the trucks won't pick it up to truck to Salt Lake City or PRT.
All right, thank you. The division has no further questions.
Okay, thank you. Just one question, Mitch. When you refer to spud date, are you talking about the conductor hole or when they first go in for production?
In Utah, spud date, as I understand it, is the first drill bit turning in the ground.
So that's the length of that time then, because
That's right. And the spud date really, at least for these purposes, it's only related to the acreage weighted royalty calculation. It's kind of its key marker. And I think it's really just as Mr. Checken said in the earlier hearing, sometimes you just have to pick an arbitrary date and say, by this date, this is when we're calculating it. The spud date actually makes a lot of sense to me, because, it is typically well before production, right? More than a year before production. But it's when the well planning, when the well costs start to kick in. So it makes sense that people would either need to elect or participate by that time.
Okay, thank you. It may have been noted earlier, but the division that filed a response, non-opposition, dated May 11, 2026. And so at this time, I understand you have no opposition to this. And would you want to just summarize your position at this time?
Yeah, thank you. Similar case, the division, they received the RAA and the exhibits, and they reviewed those. Then when the declarations came in, they reviewed those as well. And based on the testimony and the declarations and the division's review, the division still has no opposition to this request and believes that SM has met its regulatory and statutory obligations.
Thank you. Mr. Mann, would you like to summarize your position?
Yeah, again, just with a couple things first, I should probably move for admission of exhibits 1 through 5 and exhibits 7 through 15. Exhibit 6 was intentionally omitted and not included as part of this presentation. That includes the declarations of Mr. Dean and Mr. Peterson.
Okay.
No
Mr. Haynes, the division?
No objection.
Okay. Okay. We'll admit the exhibits as presented.
Okay, thank you.
And you have no objection to that, Mr. Haynes? Okay. Having reviewed the request for agency action on all exhibits, and having considered the evidence presented today, I find that SM Energy has provided sufficient notice of the opportunity to the non-consenting compulsory pool owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that a 100% for surface equipment and 300% for drilling costs as a non-consent penalty is fair and justified given the economic and geological condition presented today. I find that SM Energy has met its burden of proof to show that they are entitled to forced pool of the named interest, other relief requested in a request for agency action. Mr. Mayo, would you please prepare that order?
I'm happy to do that.
Okay, and then I'll represent them next Wednesday at the board hearing.
Okay. Hopefully I'll get a draft order sent to the three of you here by tomorrow afternoon.
Okay. Any other comments before we close?
No, I appreciate you taking the time.
Okay, thank you for your participation, and we'll adjourn this meeting at this time.
Thank you.